Yeah, they do. Do people ever exaggerate what is going on? Yes, they do. People ever exaggerate what is going on? Yes, they do. I recently had someone call me, and they live in Los Angeles, and they live in an apartment. But if you look out their apartment, their window is approximately 5 or 6 feet away from their neighbor's window. A completely different apartment building. And the neighbor has a habit of calling CPS on these people whenever the neighbor hears something that she doesn't like, cursing, yelling, allegedly, calling kids names, listening to the kids scream and yell about different things. You know, every time a kid yells or screams doesn't mean they're being abused. They may not be getting their way and being a little spoiled about something, and then the neighbor thinks it's child abuse and calls CPS. And then where are you? You know, cops come over, a social worker comes over. So all of these things you have to remember in preparing for your detention hearing. Generally, in some counties, it's not like this in LA County. The social worker shows up for the detention hearing, and if you want to cross-examine the worker right then and there, that can be done. In Los Angeles, so you generally the emergency response worker who writes the detention report is not in court, so they usually continue it. And I think the law provides you to have what's called a contested detention hearing. They used to call it a Dennis H. hearing after a case in California, an appellate case, within I think it's within 3 days or 3 court days, something like that. Now, that's the good news. The bad news is the judge could decide that instead of giving you this contested hearing, to set your case for trial, what's called a no time waiver trial, within, I don't know if it's 10 or 15 court days. And then you bring all of your witnesses. But remember, at this first hearing, you want to make a good impression, even if you lose, because you want to start putting in the judge's mind some doubts about the social worker story. It's important because the social workers are going to be writing the eventual, what they call jurisdictional and dispositional report. So it's going to be important that you get your story out there, at least, the major points at that very first hearing. Because judges are smart people. Okay. I don't care if you like your judge or you don't like your judge. They didn't get put in that position because, they're stupid. They're smart people. And they remember, just like you. They're just like any other person. And they'll remember you, and they'll remember some of your facts. One of the things I've noticed over the years is that a lot of judges take notes. You don't know this, but they take notes and they stick it in the file. Next time the hearing comes up, they pull out the file, they pull out their notes. Oh yeah, I remember that case. And the judge looks at their notes, and that's what, they kind of have refresh their recollection about what they thought and what they were feeling about your case. Okay, so don't think that your judge won't remember. He or she will remember more times than not. Okay, so that's generally how I approach detention hearings. It's a broad framework because every case is different. Some people, are accused of domestic violence. Some people are accused of emotional abuse, physical abuse, sexual abuse, drug abuse. The list goes on. Not taking care of the kid's medical condition, not sending the child to school. It can go on and on. So every case has to be looked at kind of differently and very specifically, but the importance is going through that detention report, making your notes, giving your attorney evidence, documents and witnesses that can testify on your behalf. Remember, the attorney wasn't there. He or she is in a worse position than the social worker. Social worker allegedly has talked to witnesses, has talked to people in the family, the parents, the child, the relatives, the next door neighbor. The attorney, he or she hasn't talked to anybody. So they're in the worst position to assist you, and that's why you have to help them. Don't rely on the attorney interviewing you, right, 5 minutes before the hearing. You provide that attorney, you take the offense and provide that attorney the information by way of email, and also talking to your attorney. But always have a record that you've talked to your attorney and you've provided him or her this information. I assure you, all attorneys, private, court appointed, they will all appreciate this because it will make their job easier. Okay? Now, one of the things that you should know that you do not have to continue your case after the detention hearing 4 to 6 weeks, which happens in a lot of hearings. You are entitled to what's called a no-time waiver of trial. So in some cases, if I argue the detention hearing and the judge doesn't release the child, or at least place the child with relatives, I set the case for a no-time waiver of trial so that we can get to this and decide this right away. A lot of times, your trial won't be for 6 to 8 weeks, sometimes more, after the detention hearing. And you need to make sure that your case is pressing forward if that's going to be to your benefit. Now, it may not be your benefit. There are some cases where you don't want to have a trial right away. Let me give you an example. Let's say that the social worker has alleged that you are a drug addict or an alcoholic. Okay? One of the things that you can do to win your case is to have a period of time where you've taken drug testing or alcohol testing for 4 to 6 weeks, 10 weeks out. And then when you have all those negative tests, you go into court and say, hey, judge, under the law, you're supposed to decide the case as of today. Am I a risk to my child because I'm a drug addict? And if you have 10 clean tests, 15 clean tests, the answer is no, you're not, right? And then in the disposition hearing, you have to prove that you are a clear and convincing evidence that you're a substantial danger to the child. If you've got those clean tests, the social worker can't prove that, in my humble opinion. But you can only take those tests if you take the time between the detention hearing and your trial, right? You need time to test. You need time to prove to the judge that those allegations that you're a drug addict and can't take care of your child are false. And the best way to do it in juvenile court is the test, the negative test. So sometimes you don't want to set the case for trial right away. Okay? So I hope that gives you an overall framework. Each case is different, and the burdens and the evidence are different. The law is different at that first hearing. Now, when you go to the second hearing, the law changes. There's different statutes, different rules, different evidentiary burdens, okay? Different legal tests. You have more ability to bring forth witnesses and evidence to prove what the social worker is saying is not true. So don't just think that, the detention hearing is a throwaway hearing. I get that from a lot of people, and they tell me, I heard that, at the detention hearing, we're not going to get the kids back. So it's not really a big hearing that we should be concerned about. And that's not true, because here are other things that can happen at the detention hearing. Number one, if your child was taken and placed in foster care, that's the time to ask the judge to place the child with relatives or friends of the family. At that very first hearing, sometimes the relatives are out of state. Your Honor, I ask the court to order an ICPC to consider the children being placed with my, grandfather in Nevada. Here's one of the things that you should do and consider doing at every hearing, even the first hearing, is bring those relatives and friends with you to court so that and the judge knows, that there are people out there that care about what where this child is, what's happening to this child, and that these people vote. Okay, one of the most extreme examples that I've ever been involved with, I represented a man in Lancaster, in Los Angeles County, in the Lancaster court. He and his wife had been accused of killing one of their children. Serious case. At every hearing, there were probably 150 to 200 people who came to support that family. And they were in the hall sitting down. I'll never forget the very first hearing. We got called into chambers, and not allegedly, he was there. One of the main sheriffs of the building said that he wanted all of those people to leave the premises because they were a security risk. The odd thing was these were all people from church, from one of the local churches. So, how are they going to be a security risk? Anyway, the attorney, a very famous attorney who represented the mom, I had the dad, said, look, this is a public building. These people can be here to have support. And the judge didn't get involved. Said if the people want to be here, they can be there. And if they were going to cause a security problem, you would have cause to evict them. But they haven't done anything but crowd the court, crowd the hallways. And at every hearing, they had that many people there to support them. And guess what? As the case turned out, it turned out in favor of the parents. Now, did the people there every day at every hearing have an effect? I think so. But you can talk about that with your attorney. All right, so that covers the detention hearing. Cassandra, do you have any questions for me?
It's early. No, I don't have any questions, but I do have a comment. Like when you were saying that they do the totem,
Totem
um,
pole hearsay.
yeah, totem pole hearsay. Like that's so what happened to me. It was like so I know what you're talking about. That was like way out. They brought up things from like way when I was a juvenile, even like
Right.
it was way out, and I didn't even think that they would use my juvenile stuff between me and my mom on the case for me and my kids, and they did. It
They
was,
always will.
yeah,
They have access to that information. They're the government. They know everything about you. And if they can use it against you, it will be thrown in and used against you. And it's one of those things where it may not even be relevant, but it's the kind of thing is like the judge hears it, and subconsciously it may persuade the judge, oh, Cassandra's not a good mother.
yeah. They would try to use the fact that me and my mom had problems when I was a juvenile, and that's why I needed to do family counseling because I might project it onto my children of
Yeah,
how
and that
she, yeah.
and the interesting thing is might doesn't satisfy the law. They actually have to have evidence, but unless you say that to the judge or bring that up, your attorney brings it up, the judge is going to listen to it and may or may not use that in their decision making. I was in a court a few months ago, and we were at the very first hearing, and the judge ordered my client to do drug testing. Not only drug testing, hair follicle testing. Now, the way the case law is written, if I don't say anything, that becomes the law of the case. And I objected. When I first objected, I said, Your Honor, I object. Hair follicle testing